Welcome aboard, applicants. I thought today we would begin with a bonus lesson in professional responsibility. You may ask why? Well, professional responsibility, just around the corner, would be an important class for your upcoming exam in the MPRE, the multi-states for the professional responsibility exam. So I thought, why not throw in a bonus lesson and talk about some of the topics? This is just going to be a survey. It's not going to be an in-depth discussion. We will take that up in later lessons. So let's begin our survey of professional responsibility. Now, beginning the professional responsibility discussion, as you can see on the board here, we have the creation of the attorney-client relationship. This would be based on a reasonable person. A reasonable person would understand, a reasonable client, that the attorney-client relationship has begun. And how would that happen? Either through communication with that client, or some kind of belief that the client has concerning the attorney or lawyer's conduct. Now, always be on the lookout in your hypotheticals too for prospective clients. Those that you as the attorney or client may not consider clients, but remember, leaning back on that reasonable person standard, they would consider that the attorney-client relationship has begun, which is the key and core essence of when the creation of the attorney-client relationship begins. When the attorney-client relationship is created, then we kick off into our duties discussion, and we have the duties of competence and care, which is all the skill, preparation, knowledge, and thoroughness reasonably necessary for legal representation. Always be on the lookout again for those emergency type situations where a party, an attorney, a client may have to go into an area that they are not fully competent in at the time, but that they will then refer that client to someone who is fully competent in that area. That would be the emergency type situations. Also, in terms of professional responsibility, we have the topic of duty of loyalty, putting your interest above putting your client's interest above your own interests. Remember though, if you put your interest above your client's interest, that would create a conflict of interest. Our next topic, which would be that breach of the duty of loyalty, and conflict of interest is where the meat and potatoes of our professional responsibility resides. It's the chief issue, and we will take this up on later discussions, parsing out all of the areas that represent conflict of interest. But for sake of conversation right now, there's two types of conflicts of interest: actual and prospective. And I'll leave it just like that for right now. Now, after we talk about the conflict of interest, we look at imputed disqualification. This would be if an attorney or lawyer comes into a firm with a conflict of interest of some kind, do they impute that conflict of interest or all of the possible conflicts of interest that they carry with them into the firm that hires them? That is a yes on that, and that's why we will go into that as well in a deeper with more deeper discussion on a later occasion. All of the areas that surround imputed disqualification. Now, also, our next topic would be scope of representation. This would deal with what are the types of decisions that an attorney can make, legal, tactical, and what are the types of decisions that the client can make. That would be more case specific as to the settlement aspects, whether or not they're going to take the stand, whether or not they're going to accept the plea, those kinds of situations, or a settlement offer. That would be all wrapped up in scope representation. Again, we will discuss these at a later time. Now, duty of diligence, that would be make sure that in representation you're not dragging your feet. In other words, you're not being unreasonable in your preparation concerning notifying the client about updates concerning the case, and being prompt about those representations and communications. Now, in terms of duty to communicate, we're looking at making sure that you communicate with your client on a consistent, reasonable basis concerning critical updates concerning the case. Now, there's also this is another big issue here, the duty of confidentiality. That is a huge topic. That would be all of the information that was shared to the attorney in confidence by the client that surrounds the whole legal representation, the attorney-client relationship, okay? And that would also be things even outside of the communication with the client that maybe the attorney learned from a third party about the case. That would be wrapped up in duty of confidentiality. It is a humongous duty to think about, but it's, remember, the chief of all duties here is the duty involving loyalty, the duty of loyalty, but the issue involved in that is conflicts of interest. Now, then there's attorney-client privilege, and that would be the communications between the attorney and the client just concerning the legal representation. And again, which actually would be bigger, the duty of confidentiality or the attorney-client privilege? The duty of confidentiality would be bigger than the attorney-client privilege, because it would actually be like this. The attorney-client privilege would sit inside of the duty of confidentiality, because remember, as we talked about, the representation was part of the confidences that were shared. Now remember, the duty of confidentiality also encompasses all the information learned about the case from others and other surrounding circumstances. Now, up here on our next column here, this is the duties involving fees. Those fees have to be a reasonable amount, or in California it's not have to be a reasonable amount, or as California would say, it's a not unconscionable amount. Now, and we're also going to be talking about other types of fees, like the standard fees, billable hour, the contingency fees, and what are the requirements of these. We'll take this up later. Safekeeping client property. This is the aspect about not commingling the client trust account with the law firm's operating account. Neither shall the two meet. Okay, and then the other thing about keeping client property is that when an attorney receives property from the client concerning the case, there is a proper procedure that has to be observed, and we will go into that about safekeeping that client property and maintaining that duty as well. Now, relationship with the client. If the relationship with the client predated the representation, then that relationship may be permissible. However, that relationship with the client may represent a conflict of interest if it came during the representation. Now, the advertisement and solicitation aspect concerning professional responsibility is that there's no face-to-face solicitation. And if you're going to advertise, make sure to be truthful, not misleading concerning material facts. Now, the duty of fairness, that duty goes to the court, the opposing counsel, clients, and third parties. And we will go into more of that at a later date. The unauthorized practice of law is that the attorney shall not practice law with a non-lawyer, and that would represent an unauthorized practice of law, and that party shall not practice law without a state granted license as well. Now, liability for others. This would be concerning the duty that a junior partner has concerning working underneath a senior partner. The senior partner would actually be responsible, but here's the thing. The question may be asked, is the junior partner responsible as well? Absolutely. They are responsible for reporting misconduct, which is what we're going to be talking about here, and for maintaining professional responsibility standards. Even though they might have been told by their senior partner to operate a certain way, if operating that way is in violation of the professional responsibility code, that would then fall back on liability concerning the junior partner, not, number one, reporting such ethical violations, and number two, making sure that they keep within the professional responsibility code of ethics. Okay. Now, duty to the public and the profession. This is where we get into aspects concerning like the duty of the prosecutor, the duty that the attorney client or the attorney and the lawyer has concerning the public. What can they release concerning a case in terms of information? Those kinds of issues. We will be getting into that as well as we proceed within professional responsibility in later lessons. And then we conclude here with the topic of withdrawal. When there is a need by the attorney client or by the attorney, the lawyer to withdraw representation with the client or of the client, what kind of withdrawals are possible? It'd be mandatory withdrawals and permissive withdrawals. Just to go into quickly a mandatory withdrawals, those would be things like when the client either fires or when the client fires the attorney concerning the representation, and the attorney-client privilege, that is, the attorney mental, emotional, or physical conditions do not permit them to continue to represent the client in a reasonable representation. That would be the second reason for mandatory withdrawal. And third, as you probably guessed, any violation of the code of ethics would be reason for mandatory withdrawal. There are a ton of permissive withdrawal and reasons, and we'll go into those as well in a further lesson. Also, at the tail end of mandatory or permissive withdrawal would be the duty that the lawyer or the lawyer attorney has concerning client, especially concerning safekeeping client property like documents and maybe particularly evidence that the attorney is safekeeping for the client. Those things usually have to be returned, and also tying in this other issue of fees, the also earned fees have to be returned, and we'll also go into aspects concerning those issues as well to further discuss those and to parse those out. Okay, thank you so much for joining me on this issue, or I should say on these issues, but we're going to now go into the review of negligence. In like we talked about, in negligence is present. Now, this is in negligence I want you to think about when you put down your rule statement, possibly including this. Negligence is present when the defendant's conduct falls below a standard of care and such breach of duty is the actual and proximate cause of plaintiff's injuries or plaintiff's damages. Another way of saying that as well. Now remember, and a follow-up statement concerning negligence would be the elements of negligence include duty, breach of duty, actual cause, proximate cause, and damages. Why do we bring these two together? Well, it's kind of like making sure that number one, our first statement is how we would say the negligence issues, and then the second statement would be how would we actually discuss those issues in our analysis. And that's what I wanted to talk to you right now about, is specifically the element of duty right now. So let's talk about that. Under duty, we go into three primary areas, and we think about those areas when we're looking at our fact pattern. Whom is the duty owed? In other words, when we're dealing with whom the duty is owed, is there a zone of danger issue at present? Now, I might be asking, what does that mean? Remember that the defendant owes, or I should say that, the defendant owes a duty to all foreseeable plaintiffs within the zone of danger created by their conduct. That would be the Cardozo under the Paul's Graph landmark case. Also under that particular landmark case, the Andrews position, the minority position, would say that the defendant owes a duty to the world at large. Okay, now might be asking, well, if there's no zone of danger, then do we fall back on the Andrews position? Absolutely. Do we always talk about the Andrews position? Well, I would reference to it, but not always is it going to be a relevant topic to bring up in our fact pattern. Oftentimes, we're able to find the zone of danger either surrounding a course of conduct, a product, an activity, like driving a car, driving a bicycle, walking, those kind of things. Those kind of things create a zone of danger around the person, the thing, or the activity. But remember, if the injury itself goes beyond the zone of danger, then we might be looking into that Andrews position that says that the defendant owes a duty to the world at large. This would create an answer, our duty, and to whom that duty is owed. Now, if we now have to give a face to our duty, I would argue starting out with the general duty, because it's a fallback position, as you know, that if we don't have special duty, we at least have a general duty to fall back on in terms of our analysis when we proceed down to a breach of that duty discussion. Okay. Now, under general duty, we start with the reasonable, prudent person. I'll highlight that right here for you. Why is that such a big deal? Because it's that reasonable person in the same or similar circumstances that we're looking at when we establish whether or not a general duty is owed by the defendant to the plaintiff. Now, we have interesting situations that might pop up and would increase that reasonable, prudent person, or elevate that person to another standard, a higher standard, and that would, well, let's take first the specialist standard. Well, the specialist would be elevated, would elevate the reasonable, prudent person to the standard commensurate with the fellow circle of specialists that the specialist is within. If they have operated within that, that's the kind of standard of care that the defendant owes to the plaintiff. Okay. Then, if we're dealing with a child and the child standard of care, this would be a child of age, a similar age, intelligence, and experience. So our defendant here would have to operate as a similar child with similar or same age, intelligence, and experience. However, be watching out, and I'll put a little asterisk right here for us, for the adult activity. If that child is engaged in an adult activity, then that would elevate that child standard of care, that reasonable person standard of care, to the adult level. Again, that reasonable, prudent person, again, standard. Now, we also look to see if we're dealing with public utilities, if we're dealing with common carriers and innkeepers, which owe to the plaintiff an utmost standard of care. Okay, and an utmost standard of care is the highest of all standards of care. So we take our reasonable, prudent person and bring it to the highest level, that utmost standard of care level, if we're dealing with public utilities, common carriers, and innkeepers. Now, if we've found a general duty, we're not done yet. We should be looking for a special duty. Under special duty, we have three primary things we're looking at, or looking into to see if they're present: landowner, land occupier, omission situations, violation of a safety statute. Now, if we're dealing with the landowner, land occupier, look to see if you're dealing with a trespasser. Remember, trespassers in general are not owed any duty. Any duty concerning what? To warn, make safe, inspect concerning known or obvious dangers. Now, if you're dealing with a known trespasser, if you're dealing with a child trespasser, that bumps that standard of care, which is no standard of care, to what? To equal to or the same as a licensee in essence. So he would be the warn or make safe of known or obvious dangers. Now, if we're going into licensees like social guests, those types of situations concerning on the land type injuries, the landowner, land occupier has a duty to warn or make safe of known or obvious dangers. And you might be asking yourself, is this the same as the known trespasser, child trespasser? Absolutely. We just said that. So that if you're dealing with a known trespasser or a child trespasser, same standard as the licensee. Back to licensee for a minute. Under licensee, remember, warn or make safe of known or obvious dangers that would be understood, okay, or that could be understood. Now, if we're dealing with an invitee, now invitees come in two types of flavors. We're dealing with a public invitee, like museums and places, public places that are open to the public, or business invitees. In other words, bringing people onto the property for a business purpose. Now we not only have the duty to warn or make safe of known or obvious dangers, but we also have the added aspects of doing an inspection to discover any reasonable known or obvious danger. And that would be more along the lines of like shopping centers and basically shopping centers and business land related activities that cause harm to our plaintiff, excuse me. And then after we've established that if there's a landowner land occupier situation, we also look to see, has there been any omission style situations? In other words, remember, the general duty under omission is that there's no general duty to come to another's aid. Okay, now remember though, there are exceptions, and here are the exceptions. To begin, we're talking about those who actually created the peril in the first place. They would then owe a duty to the plaintiff for creation of the peril. Number two, if they didn't create the peril, but in somehow coming to the aid of the plaintiff, they've worsened the peril. In other words, they've worsened the situation that the plaintiff is currently experiencing, then they would owe a duty, and they would owe that special duty. And also under those rare and sometimes special situations where the party, the defendant, starts to begin medical aid, they have to continue to continue in that medical aid until medical professionals take over, or they breach that duty. But remember, in the beginning of the medical aid, they have in essence created a special duty. Now, it's also very similar to worsening the peril if they worsen the peril. Okay, now under special relationships, that would be more along the lines and center in family relationships and those relationships based in contract. Now that would create the special relationship that we talked about up here. Special relationship, that would be the special duty aspect up here. So again, under omission, there's no general duty to come to another's aid. Okay. Now, unless we're dealing with someone who created the peril in the first place, worsened the peril, began to render medical assistance, or that there was some special relationship between the defendant and the plaintiff, like a family member, a spouse, or some kind of contractual relationship. Now, if we're dealing with a violation of a safety statute, which I want to make sure we give it to the proper name, negligence per se is what we're wanting to say here. Now, we looked at three particular prongs in our discussion. Number one, what was the type of harm prevented? Number two, was the plaintiff within the class of parties protected by that statute? And number three, that the defendant did not have any excuse for their conduct, like maybe pulling off to the side of the road to tell their employer that they might be a little bit late in getting to a business meeting of some kind. There's no excuse for speeding. In other words, to get to or breaking the speed limit in order to get to a business meeting, that would not provide the defendant an excuse. Now remember, there are those emergency medical style excuses that may be present in our hypotheticals that might provide the defendant excuse for their conduct. However, in general, those are rare, few and far between, and so therefore we have to look to see whether or not there is an excuse for the defendant's conduct. Oftentimes, though, there's not. So, in other words, that defendant should have pulled over to the side of the road, called maybe their employer, and told them ahead of time that they would be late for that particular business meeting, rather than breaking the speed limit, like we talked about in our example here. Now, going back again, reviewing our special duty, we look to see about landowner, land occupiers. Are we dealing with trespassers, which are owed no duty of care to warn, make safe, or inspect of known or obvious dangers? Are we dealing with known trespassers or child trespassers? We do have a duty then at that point to warn or make safe of known or obvious dangers. Are we dealing with licensees, those that are special guests, like party guests and stuff like that? We do have a duty to warn or make safe of known or obvious dangers. That would be readily apparent. Now, we'll also look to see if we're dealing with an invitee. An invitee standard of care concerning a business invitee or a public invitee, and in that instance, we would not only warn or make safe of known or obvious dangers that would be readily apparent, but also we would do a reasonable inspection to discover any known or obvious danger that would not have been discoverable without that particular reasonable inspection. We look to see about omission, no general duty to come to another's aid, unless that party created the peril, worsened the peril, they began to render medical aid, or there was a special relationship through family or contract between the plaintiff and the defendant. We'll look to see whether or not there was a violation of a safety statute through negligence per se, and we look to see whether the type of harm was the type of harm prevented against by the statute. The class of parties was the plaintiff was in the class of parties protected by the statute, and that there was no excuse for the defendant's conduct. Okay, this is where I'll leave off on terms of our negligence review for right now concerning duty. I thank you so much for tuning in and spending some time with me going over professional responsibility, our bonus lesson, and going over negligence and specifically diving into duty, to whom the duty is owed, general duty, and special duty. Thank you. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Thank you again for tuning in. Keep a lookout for more videos and fun going through a bonus lesson and further review in negligence. Thank you and have a great day. Thank you for tuning in, and God bless.